subject of my presentation is on the mistaken belief in the power of law, not only with respect to demographics. One of the focal points of the research done by the Family Law Group within the framework of the Central European Professors Network was the relationship between law, particularly family law, and demography. We have analyzed all possible contingencies on how the law can improve dramatic demographic situations in our countries. I'm not familiar with the results of the studies of the other group members, but the conclusions I have arrived at are rather pessimistic. In Poland, the helplessness of law is turning the tide of demographic processes can be observed in many areas. In recent years, there was initial high expectation that the introduction in 2016 of strong social support for families raising children would stop to negative birth rate. Yet nothing of that sort has happened. Perhaps if the aforementioned support had not been introduced, even fewer children would have been born. Yet the latter claims remains unproven. Undoubtedly, however, the decline in births over the past few years has been dramatic, with fewer than 300,000 children born for the first time last year. This is the smallest number since World War II. To begin, those demographics have not been affected by the content of the abortion law, although the abortion ban may have caused an increase in the birth rates. Since 1993, out of all European countries, Poland has had perhaps the most rigorous law that protects the lives of children. A few abortions are performed every year in Polish hospitals and perhaps some abroad. Yet, this ban has not had a positive effect on the birth rate. On the contrary, a sharp decline in births immediately occurred when the anti-abortion law was introduced in the mid-1990s. Meanwhile, countries with extremely liberal abortion laws, for example, Sweden and France, have achieved fertility rates at the highest levels in Europe in the last decade. Given the above, I should be stated that the anti-abortion law prevents abortion in Poland, but does not affect procreation decisions. There is even a thesis that it generates fear of having a child with disabilities and thus discourages people from having children altogether. Legislation liberalizing the present abortion law is just being introduced and remains to be seen what effect it will bring. In the fall, I turned in for publication an article of divorces issues largely devoted to a book by the Polish demographer Edward Rosset titled Divorces, which was published in 1985. Rosset sounded the alarm about the negative impact of divorce on demographic developments. He pointed out what should be done to reduce the divorce rate. Moreover, Rosset criticized the liberal laws then in operation and the liberal approach of judges to divorce. He saw the greatest opportunity is countering divorce by educating children and young people to respect marriage and parenthood. Alas, his cautionary warnings and advice were of no avail. While he prioritized family, modern pedagogy focuses in attention on children, women, and men, with all treated separately, and the perspective of seeing them as an interconnected group responsible for each other is retreat. Parents are also increasingly failing to set a good example for their children. A significant increase in the number of divorces has been observed despite two facts. First, Polish law continues to implement the principle of the permanence of marriage, and second, it has not followed the trend of simplifying divorce procedures. The list of examples concerning the helplessness of the law in general and the dedicated to the family in particular is extensive. Bearing this in mind, I will concentrate in the remaining part of the power only on the topic of this presentation, the causes of this helplessness. Reasons for the helplessness of the law. First, the depth and complexity of social problems. Second, changes in the views on the family. And third, the crisis of the law. I will skip the first aspect because it is too complex to briefly present it here. Besides, there is comprehensive sociological, political, economic, and legal literature on the topic that is widely known. Point 2. Changes in views on the family, among them as the impact of secularization and development of ideological narratives downplaying the family. In Europe, the natural desire to have children is on the way, and the desire not to have children on the rise. This is the result of many contributing factors, such as the sexual revolution, the development of contraception, the separation of the sexual function of marriage from the procreative function, the wide availability of abortion, the increasing trivialization of human life, the development of consumerism, and a culture of selfishness. We are thus witnessing the appearance of a new phenomenon labeled as the postmodern cult of childlessness, that is the voluntary resignation of a will to have children. This can be understood as an attitude adopted by people who want to live without obligations, without deep relationships, and especially without parenthood, because they view all those aspects as limitations. This attitude is euphemistically called individualism. It is sometimes reinforced with slogans about saving the planet from overpopulation, the demand to reduce the human-generated carbon footprint, and even criticism of those who choose to have children. Arguments endorsing children as irreplaceable social capital and as a source providing a sense of meaning in life are not treated as convincing or relevant. And there is no way the law can reverse this trend. Point 3, the reason for the ineffectiveness of the law is its ever-deepening crisis. The law cannot arrest civilization change, such as urbanization, industrialization, migration, secularization, and the negative impact of the functioning of families, even if it were crafted optimally. Unfortunately, the law does not function optimally. It is not rationally created, and it is irrationally applied. It is going through a crisis which manifests itself in a variety of ways. The idea of curing serious social problems with the help of the law today can be compared to the idea of improving the healthcare system by a patient in an intensive care unit. Here are the most significant symptoms of the diseases affecting law today. Pluralism in society, which is an asset in itself, does come with some trade-offs, and one of them is a weaker impact of legal norms when compared to the past. The impact of moral, religious, and social norms is also weakening. After all, in a multicultural society, a variety of ethical norm systems, different religions, and different customs operate on equal footing. This diversity makes extra legal norms less and less supportive of the impact of legal norms. It promotes the postmodern deconstruction and fragmentation of society, which weakens the chances of saving a cohesive social order. Therefore, opportunities to appeal to roles shared by all are weakening. Consequently, those dealing with the legal protection of family are now facing a plurality of different, sometimes antagonistic, strongly argued positions representative of significant manifold social groups. This produces myriad effects across the country. Many effects concern the family as well as other issues, for example, education, the economy, and even defense. It is observed what a change of government involves the risk of significant and sometimes radical legal changes in the above-mentioned issues, which all require stability. In the context of this diversity, today it is the legal norms that have the strongest power, for they are the only norms that apply to all citizens. The strongest power, however, does not mean that it is strong at all. We live in an era of proliferation of laws. Too many highly elaborate legal acts are being made. Changes are numerous and frequent. They baffle even scholars who are experts in a particular area of laws. The total volume of legal acts published annually in the 21st century in Poland is about 20,000 pages. As mentioned, they are detailed and wordy, which is justified by a need for legal precision. Yet, it is well known that precision is lost in an excess of words. On an unprecedented scale, can we notice the juridification of public, social, and economic life? That is, almost every area of life can now be regulated by law. Such a huge number of regulations result in limiting the freedom of citizens, and all this generates bureaucracy. Societies have more or less been colonized by the law. Excessive state interventionism, which is a contradiction of freedom, has become a feature of modern democracies describing themselves as liberal. This also applies to family issues. Another major cause why the law is helpless is that the law is written in a way that is incomprehensible to citizens. It looks as if states do not care about good communication with the public. The idea of the rule of law is replaced by the idea of a role of lawyers, for lawyers. As a result, the language of regulations and the language used by lawyers creates a chasm between citizens and the state. Lawyers have been elevated to the status of experts of secret books. The apt phrase, "mullahs of the West," was formulated in relation to judges, but it can be extended to other groups of lawyers as well. After consequent widespread problem is the eroding trust in judges. This derives from many factors: long and incomprehensible procedures, legal injustice, politicization of the judiciary, and demoralizing legal corporate protection. In Poland, the crisis of the judiciary is further increased by the lack of decommunization of the courts after 1989. The failure to cleanse the courts of former Communist Party members sent a signal that spineless people, those who mostly belonged to the Communist Party as a result of opportunism, were perfect candidates for the profession. Communism in the judiciary terminated for biological reasons. But before their departure, the judges brought up politically entangled successors. The problem continues to the detriment of the judiciary. Still, another major cause is that the rank of the law has also deteriorated in the wake of legal activism, not only of judges. This is an extremely broad issue. Here I would like to point out the disturbing behavior of judges, especially family judges, but not only, that contradicts the principle of the tripartition of power and the rule of checks and balances. This can be observed when lawyers, judges, take on the role of legislators and rule as they see fit, detached from the legal text. In other words, they rule based on legal norms that does not exist in the legal system. Neither is it expressed in the laws, nor can it be interpreted from the laws. This can be seen clearly in the invocation of general clauses, the welfare of the child, the welfare of the family, without indicating how the court understands them in a particular case. The judges essentially step out of their role and enter the role of a legislator by ruling on a legal basis that exists only in their imagination. This approach to the law also applies to lawyers, scientists. The result of the erroneous view that the law must regulate everything precisely is the disappearance of the ability of lawyers applying the law to interpret regulations. Legal literature contains numerous examples of the supposedly scientific text, informative in areas only concerning the content of regulations, and devoid of their dogmatic, functional, and axiological analysis. And yet the capacity to interpret is the most important legal skill. Finally, after joining the European Union, a problem of the systemic nature arose concerning the system of sources of law that gives rise to questions: what is the source of law, what is the hierarchy of legal act, and what is the hierarchy of the courts. In Poland, this is a problem aggravated by the aforementioned political involvement of judges. The law is thus depreciated. Conclusion. My Roman law lecturer the long-dead Professor Kazimierz Kolańczyk, began one of his lectures by saying in a nostalgic voice, "And now we will enter the enchanted world of Roman obligations." Unfortunately, when lecturing to students about modern law, I cannot elicit the admiration that Professor Kolańczyk displayed for the subject of his lectures. Yet a year-long reflection on the law as an instrument for triggering a demographic change has led me to ponder on the law in general and its evolution in particular. Regretfully, I cannot fail to notice a constantly deepening crisis in the law, and I consider it a mistake to regard the law as it is, that is, as a tool that can effectively be used to fix important social problems. To fix the current state of reality concerning the law, we should first try to cure the sick reality of law. I'm sure it is not only Polish problem. Thank you.